This is a webinar about child custody issues in Washington State. I'm going to be joined here in just a moment by Michelle Dellino, who's going to be hosting your webinar today and taking you through all of the different information and the need to knows about child custody in Washington State, as well as some holiday specific tips. Just introduce myself quickly. My name is Melissa Rosenberg. I am a private practice therapist who specializes in the area of divorce and separation. And I work with clients, both individuals and couples, at the early stages of trying to determine whether they're going to stay together or move toward separation. I work with individuals in counseling who are navigating challenging divorce situations. And I also work with people upon completion of their divorce as they're looking toward their next chapter. But today I'm here to sort of just help facilitate and pitch questions to Michelle and help get us through this webinar. So what we're going to do, Michelle's going to take it over for me here in just a minute, but I want to let you know about a couple of features of the webinar. Down below on the bottom of your Zoom screen, there's a chat and there's a Q&A. If you would like to ask questions throughout this webinar, you can ask them in either place. If you pose a question in the Q&A, you can choose to ask it anonymously, or you can have your name listed. That's your choice. Or you can also put them in the chat. And if you put them in the chat, they'll just come to me. I'm making it so that the attendees can just only chat with the host. So either way, I'll take a look at as many of the questions as we can, pose them to Michelle, and we'll try to deliver as much great information in this hour as possible. So thanks for being here, and I'll turn it over to Michelle.
Hi, thanks for being here. I'm Michelle Dellino. I am the owner and managing attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we actually take cases all over Washington State. So we have probably seen every family law situation that you can imagine. I've been doing family law for almost 15 years. My practice focuses on high conflict cases, also complex financial cases, and pretty much anything that relates to family law. So first thing for you to know is that there's no attorney-client privilege associated with you coming to this webinar and asking a question or being on this webinar. No one can see the other people on this webinar, but so if you ask a question, make sure and pay attention to what Melissa said about sending it to her confidentially as well. But at the end of the day, there's no attorney-client privilege that is attached, which means there's no legal advice being given by me. I am an attorney, but I am not your attorney unless you have a specific contract for legal services with me. Or if we are having a private confidential consultation, then that is a conversation between you and I. That's not the same thing as a webinar. So I just have to make that abundantly clear that just because you came to my webinar doesn't mean I'm your attorney or I gave you any advice. That being said, I'm going to give you some information that I hope is going to be helpful. And what I would love it if you do is you ask questions, because I could talk for hours upon hours about custody, but I don't know if that would be as interesting to you as it might be if you actually ask a question. The last thing I'll say before I start is that if you ask a question that's very fact specific, like tell me what to do in this situation, and you give me a hypothetical, those situations are fun and I like to work through those, but that's not helpful for everyone. And it's like, it takes way too much time. So general questions, or if I can find a way to generalize a question that Melissa gives me, I will do that. But it's just impossible for me to answer hypotheticals or specifics without having a consultation with you about your specific situation. So I hope that helps. I just wanted you to know if we don't get to your question, that could be why. So, all right, we're here to talk about custody. Now, first thing I'm going to say right off the bat is Washington courts don't use the term custody nearly as much as other states do, but custody is still kind of the overarching topic. So I want to talk about, what does custody mean in Washington specifically? And when does it come into play, right? So custody is who has your kids, right? And all the things that go with that. In Washington, there's no such thing as a custody order. We have what's called a parenting plan. If you get divorced and you have children, the court will require you to enter a parenting plan in your case. So you will enter a parenting plan either a few different ways you get to that plan, either by agreement and negotiation with the other party, by going through a mediation where you agree on it there, by an arbitration where an arbitrator decides if you've stipulated to do that, or a trial court will enter a final plan. So a parenting plan, though, will have to be entered at the end of your case. And it's called a parenting plan, not a custody order. Although if you have a custody order from another state, it may be able to be registered and recognized here. So that's a whole other issue. In that parenting plan, there is what is called a residential schedule. The residential schedule in the current parenting plan, I believe, is Section 8. If you're looking at a parenting plan and you're like, what is on here? There's a form that you fill out, although all parenting plans are not created equal, and we'll get to talking about that. But in your parenting plan, you will have a residential schedule. And that's kind of I would say that's like really the nuts and bolts of what is important to most people. That is, where are the kids going to be and when are they going to be there, right? Like that's kind of the biggest thing. There are other important parts of that parenting plan that we'll also try and talk about today. But Section 8 is the residential schedule. That is who determines who has the kids when. And there are other important designations in that parenting plan I'll talk about right in the beginning. One is the designation of custodian. So what does that mean, actually? There are two types of custody in Washington. One is physical custody. That is like, who has your kid? Like, I have this can of Spindrift. I have physical custody over this, right? So this is mine because I'm holding it. If I'm not holding it, I don't have physical custody over it anymore. So if this was a child, it's in my house, it's here. If it's at the other parent's house, that parent has physical custody during the time. That's a very easy thing. Then there's legal custody, okay? So legal custody, I have this tablet that I like to take notes on. So I own it. It's mine. I bought it and I have it with me right now. And I have legal custody of it because I own it and I get to make decisions about it. I could leave it at the other room or at my office or wherever it might be. And just because I don't physically have it with me doesn't mean I can't make legal decisions about it. So apply that to a child. You have a child, it's with you at home. Great, you have physical custody and legal custody at that time. It's at the other parent's house, it's at school, it's at grandma's, it's at soccer. It doesn't mean that you don't have legal custody of the child just because it's not with you. That's the point that I'm trying to make here. So legal custody refers to who gets to make decisions about and for your child, right? So that might be a decision about non-emergency medical care. That might be a decision about education. That might be a decision about extracurricular activities. There's all kinds of decisions that you make for your child because they're minor and it would not be good to have them making those decisions and they legally can't, right? So you and the other parent might both have legal custody. Most of the time you'll have the legal decision-making rights over your child. And we'll talk about that more as it pertains to a parenting plan. But the physical custody is just where your child is when, right? That's it. So that's some basics for you to know. Now, everybody probably wants to know, well, I am trying to work out a parenting plan. I'm trying to figure out a parenting plan. What should I put in my parenting plan? Who gets the child? How much? That is all very fact specific. So I'll talk about some basics for you to know. That's going to depend on the particulars of you and the other party. It's going to depend on how old your child is. Are there other children? Are there multiple kids in a family that are under the parenting plan? Is it just one? How far away do you guys live from each other? What's the work situation of the parents? Where's the child's school? All kinds of stuff. The thing for you to know is that establishing a parenting plan in Washington, there are specific factors that a court will look at, but the overarching big umbrella standard for a parenting plan is what's in the best interest of the child. It's not what's better for you or what's better for the other party. It's what's best for that child. That's really what the court wants to know. And so in doing that and making a parenting plan, the court will look at different factors in determining where do we go from here? What kind of a plan is right for this family and these children, right? So again, it's kind of a big thing to know. Another thing I'm going to touch on briefly is about restrictions in a plan. In the very beginning of a plan, there's a section called Section 3, and it talks about different types of restrictions. It's like right on the first page or the start of the second page, depending on your plan. And it says, if parents have any issues that might require restrictions in their plan, what is a restriction? If you're in the middle of a family law case, you might have heard the term 191 restrictions. That refers to a subsection of the Revised Code of Washington and domestic violence that refers to the subsection 191 about what restrictions are in a parenting plan. If you have 191 restrictions in your parenting plan, that is a basis to limit the time with your children under the residential schedule or the decision-making that we talked about as it pertains to legal custody, right? So restrictions, different types of restrictions exist. There are restrictions for domestic violence where one party or the other has committed domestic violence against the other party or against the children, or there's a nexus between that domestic violence and parenting. Domestic violence is a reason to restrict time and decision-making in a parenting plan. Other bases for restrictions can be neglect or abandonment, not seeing the child for over a year, not having contact with the child. There can be restrictions for substance abuse and mental health restrictions, but I want to clarify that just on a very surface level for you as well. There needs to be a nexus between an issue that a parent has and their ability to parent. So it's a lot of people are under the misconception that it's like, oh, if I'm going to therapy or counseling or I have a mental health issue or diagnoses, is that going to be used against me? The answer is no. Actually, courts like to see people people in therapy. They like to see people taking care of themselves. Melissa has a lot of clients going through the divorce and separation process, and it's like the healthiest thing for them. And so that way, if there's questions, you can be like, hey, I'm dealing with my issues. I'm taking care of my issues. What about you? And so it's not something that's going to be used against you. And even if you have, a diagnosis, or you're taking SSRIs or any of these things, people get really scared when they talk to me about, is this going to look bad? And the answer is not, unless there is a nexus between your mental health issues and your ability to parent. Or like your substance abuse. Just because you drink alcohol doesn't mean that you have a substance abuse problem that interferes with your ability to parent. So there's a lot of specific applications there, but that's something else to know about the 191 restriction section. The other thing, though, to talk about in your parenting plan is designation of primary custodian or not. And so there's a section that specifically designates that. And I started out talking about physical and legal custody because it's important to know what that means. A lot of people see that in their plan and they freak out. They're like, oh my gosh, does that mean I'm not the custodian or whatever? No, primary custodian is really for a designation with the IRS about who should be claiming the child. And that's a whole other thing we could talk about too. But typically the parent who has more nights is going to be named as the primary custodian. And it's very clear in the plan. There's very boilerplate language there that will say this designation doesn't affect the other parent's, rights to the child. It's just a designation. And in a 50-50 plan, it's not uncommon for both parents to be named. It'll say both parents, or sometimes it'll alternate every other year who's named. The other reason that matters is because there is a relocation statute as it relates to custody that deals with one parent's ability to serve a notice and relocate with the child and the other party's ability to respond. But relocation is a separate webinar. I think I did at one point, so you should watch that, or maybe we'll do it again in 2024. So the designation of primary custodian typically relates to who has the children more nights. And I'm going to talk about schedules, residential schedules and custody schedules in a minute. But before I do, I should probably stop and ask if there are any questions.
Yeah, there are a couple questions, and some of this you have covered a bit, but maybe we can just kind of do some reiterating on the questions that we have. Mm-hmm. So one participant asks if the primary parent, me, in this case, the mom, has full parenting rights, legal custody, and father has phased access with specific stipulation and is not meeting criteria for that access. What action do I have to take and be mindful of? And then there's another question about how could I move freely, like to BC, for example.
Got it. Okay. Great question. I deal with clients pretty much all the time. The minute that you said this, I was like, oh, this is something I dealt with recently. So if a parent has a phased-in parenting plan, I'm glad you asked, because I'm going to talk about that with different types of schedules. A phased-in parenting plan is usually where a parent starts with less time, and if they meet certain requirements, then they're able to move on to the next phase and get more time. So you're asking, well, what if they don't do it? So it's pretty clear. If they don't do it, they don't get the time. And this is where we come down to the difference between a good parenting plan and one that you, like I call a DIY, where you did it yourself and then you regret it later and you're dealing with it because your language isn't clear. So you need a good parenting plan if you do a phased-in plan that's very clear about what happens if a parent doesn't progress. So typically, if a parent doesn't progress, and this is also too, I'm saying notwithstanding other language in your plan, but basically if a parent doesn't progress, they don't move on. And if the parent is saying, like, I should move to phase 2, I should be getting overnights now, and they didn't do the therapy they were supposed to do, they didn't submit to the UAs or whatever they're supposed to do. If they didn't do those things, they don't get to. And if they try, and you can say no, and if they try to move ahead and enforce the parenting plan, then you can say no, and then it's up to them to try to deal with it through the court. They don't move on if they don't fulfill the requirements of the phases. I like specific language in my plans that specifically says to, or if a parent has like a sobriety requirement or some kind of a treatment requirement, if the parent does not meet it and they're in phase 2 or phase 3, they go back to phase 1, or their visitation is suspended. Like you really need to be clear about those things in a plan. So it really is very fact specific to your case. But in general, if a parent doesn't do the things it takes, they don't progress. And they might disagree with you about whether they've met the requirements or not. So that's where it also comes down to needing to have very clear language with requests, with specific requirements. A very common thing we'll see is, well, they weren't available for me to schedule that evaluation, or they weren't available for the treatment, or I couldn't get it done in time. A lot of things like that. So you need to be really clear in your plan. plan. But to answer your question in general, they don't move on. And if they try, or if they're in a higher phase, then, and you don't have clear language on it and you want to suspend the plan, then you might want to address it with the court so you don't end up in a potential contempt situation. But in general, they don't move on if they haven't met the requirements. Like, that's just it. A phased in plan too isn't necessarily always because someone did something wrong. So I want to clarify that. Sometimes it happens with younger kids because there are specifics with parenting plans where it's not appropriate for like a 3-year-old to be on a 50-50. They need more stability in their primary location, right? But it doesn't mean they're not going to move to a 50-50 maybe later in sharing equal time when the kids are older or it's more developmentally appropriate. So a phased in plan can be to account for the ages of the children or the location of the parties. It's not always because somebody like needs treatment or something, but a lot of the time it is. So there's different types of phased in plans. So anyway, I'll move on. Melissa, yes.
Yeah, I mean, this participant also asked about moving to out of state, and you kind of mentioned that relocation is kind of a whole nother topic.
Yeah,
so
let me give you a 1 minute like soundbite on that. Relocation, there's a relocation statute in Washington State. You have to comply with the terms of the Relocation Act. Generally, if you're the primary parent, and I'm saying generally, because if you're on a 50-50, it's different. But if you're the primary parent, I think it's 45% of the nights. Anyway, I'm not going to go into the statute, but you can talk to somebody about the statute in your situation. But anyway, if you are the primary parent, generally speaking, you are required to give notice of intent to relocate with the child no later than 60 days before the move. So you've got to give it at least 60 days before you're planning to move, and you need to serve the proper notice. And so when you do that and you serve the proper notice, the other party then has 30 days. They've received notice and opportunity to respond. They have 30 days to respond and say they don't agree with the move. And then they have to set a hearing to stop the move before a trial. So they basically respond, they open a case, they say, I don't agree. They set a hearing, and then you basically are like, nope, I should be able to move now. And then there's a whole process that unfolds. But you cannot and you should not move without giving notice. If you do, I have seen people be ordered to move back when they probably would have had the relocation approved in the first place. But now they look like they're in bad faith because they didn't follow the rules. So it's really important if you're thinking about relocating with a child to do that. Here's the other thing to know too, is that if you are thinking about relocating, your notice of intent to relocate and your reasons for relocating are really important. There's a number of factors the court will weigh when it's looking at whether relocation is in the best interest of the child and whether it should be happening. It is presumed, if you are the primary parent, that you will get to relocate, but the other party, it's a rebuttable presumption, basically. So I hope that's helpful.
Thank you. Yeah. Okay, another question. Yeah, another question. How is physical custody typically determined for a child under the age of 2, especially if they're breastfed?
Good question. Well, first of all, it used to be that, like, if they're breastfed, that was a reason to have children not like leave mom. It's not anymore. Now, I mean, I hate to say this to you too, like, I don't know if there's new moms out there listening, but I actually had a court order a couple of years ago, the mom to pump the breast milk and drop it off with the kid. I mean, that's not something that is above and beyond the grounds of the court to do. So every different judicial officers feel differently about that. But in general, I think it's worth talking about kind of general standards for parenting plans. The AFCC, which is the Association of Family and Conciliation Courts, puts out some standards that are super helpful. You could even go to the AFCC website if you want and look at the standards. There's a lot of information there. A lot of it's not relevant to you. It's more for professionals, but it's very helpful, and it talks about what's developmentally appropriate and what's not. Children under 2 are not going to be on a 50-50 plan. If they are, that's probably not a good move by the court or by you if you're agreeing to it. A 50-50 plan is going to happen for kids when they get a little older, but younger children are not going to be expected to be on a 50-50 plan. It typically starts with, depending on evaluating, like, how far you're going to be having this very young child travel. What does the situation look like? It's different if a parent lives like half a mile away than if they live an hour away, right? And that will determine whether it's going to be, an every other weekend, or a child in the middle of, seeing the child in the middle of the week, or your specifics are going to really determine that. But 50-50 is not appropriate. At least a couple of nights a week for a child that's 2 is totally appropriate. But it really depends on the specifics of the situation. So anyway, there's a lot of different developmental guidelines that you need to look at. When kids get a little older, when they get to be like 3 and 4, a 50-50 is still not great. But if there are other children as well going with the child, then like there's older kids in the home, then it's totally appropriate. When kids are older than that, it's even more appropriate. Types of 50-50 schedules is the question. But one thing for you to know too is that I'll tell you this, when I started practicing, it was very common for it was usually mom, because mom usually had the kids more before, mom wasn't working. Now it's not necessarily usually mom. Mom would have primary and dad would be every other weekend. That was really common. Now that is not common, and that is usually not going to happen for most people unless you really want that or there's a reason. Then it kind of got to be every other weekend, went from Friday to Sunday to Friday to Monday. Okay. And then it kind of went to every other weekend and a midweek. We called it a dinner visit, where it'd be like Wednesday on the off week, the parent would take the kid to dinner. Then it kind of went to every other weekend plus Wednesday to Thursday overnight. Then it kind of flexed up to what I call the fat weekend schedule, Thursday to Mondays. There's definitely been a progression in what's appropriate for children, and it's really resonated with the court that children should have time with both parties unless there's a restriction, like I talked about earlier, and a reason not to. So, or unless it's not developmentally appropriate. Another thing to think about too is you might have a child on a 50-50 schedule when they're younger, when they're like 4 or 5 or 6, and they're on a 2-2-3, where it's 2 days with mom, 2 days with dad, and then a 3-day weekend, and then it switches. And so it's equal time. And that's good because it's been shown that kids at that age need to see both parents. They can't go a whole week without seeing both parents. It's not good for them. But then later, when they're more teenage kids, a week on, week off might be better, because then they get to kind of settle into both homes and they get to see their friends. And it's developmentally appropriate for them to have a week with each parent. But when they're younger, there's a lot more transfers, unless there's a reason not to, of course, to make sure that both parties have ample time with the kids, and the kids are not going super long time without seeing mom or dad, or if there's 2 moms or 2 dads. So I'll take another one, Melissa.
Okay. Lots of questions pouring in on both the Q&A and the chat.
I can believe it. It's a hot button issue to custody.
Okay. So can you say a little bit more about the primary or the main custodian in terms of decision-making for the child, and what rights does that create for the primary custodian?
Basically none. And let me go back.
State and federal statutes. Can you say more about that?
Yeah. And literally, we're not going to get into that here. What I can tell you is the primary designation in the parenting plan is meant for, like, and this gets into child support too, and I don't want to go there today because we don't have time. But if you're the primary parent in the parenting plan, and the other parent's going to claim the child, then IRS form 8332 will be required to be filled out, because one parent is designated primary custodian. But if the other parent's paying child support, the court can and will order that exemption to alternate every year and order the other parent to fill out form 8332. So it mainly relates to that, or it relates to the relocation statute that I talked about. It does not have any bearing whatsoever on decision making, which is legal custody. So let me talk about decision making for a minute, because I bet people are wondering about that. Decision making is who gets to make the decisions for your child. And there is a section on that in your parenting plan, and it will specify what decisions are joint decisions. Well, that is usually non-emergency medical. And when I say non-emergency, and this is usually the biggest hot button one, emergency medical, you get to make decisions for the child when they're in your care. Your kid falls down the stairs and they hit their head or they break their leg, you're taking them to the ER. You're not calling and being like, do you agree for me to take my kid to the ER? No, you're going, and then you're notifying the other parent. But if you have a child and you want to sign them up for therapy, or they need to get orthodontics, is another really big one that comes up. Or, there's a non-emergency decision like appointment, like a wellness visit. Those are joint decisions. And it doesn't matter who has the kids more, unless it's a situation where you have a long distance parenting plan, which I already know we're not going to have time to talk about those today, but long distance plans are different. And sometimes one parent will be given more of the decision making because it makes sense, because the other parent lives around time differences or whatever. But physical custody, like if one parent we look at custody, we look at out of 14 nights, we look at a 2-week period. So you'll hear, oh, it's a 6 out of 14, or it's a 5 out of 14. If one parent has 5 out of 14 nights, the other parent has more, that does not mean that they don't get to make those non-emergency medical decisions, or that they don't get to have educational decisions. The common joint decisions are non-emergency medical, education, sometimes work-related or other childcare, but not always. Usually it's easier and better for people to make decisions about who their childcare is going to be on their time, but sometimes that'll be in a plan, and extracurricular activities. especially if it's going to financially obligate the other party or be on their time. And there's different ways you can deal with that. Other parenting plans go further to have cell phone usage, social media usage, joining the Army or ROTC before 18, getting tattoos and piercings. Like, some people really take it to that level, and there's nothing wrong with that. But it's important for you to know that decision making is going to be joint. And this is the thing I deal with. I'm just going to put this out there. Some people may be listening in this boat. Well, I always made the decisions. He or she never cared about when the doctor's appointments were. They just let me handle it. That was my job. They never cared. And now they're acting like they're caring. They're trying to use it to control me. I'm not saying they're not, right? But it doesn't matter. Now that you're not living together, the same rules don't apply. And the last thing you want to do is be found in contempt for violating the decision-making provision. So there's different ways you can do that. Again, I'm going to go back to best practices in a parenting plan. In all of my parenting plans, I will put in there, what is the protocol for making these decisions? What notice does one parent give to the other? How much time does that person have to respond? And I like to do that because if you have a parent that's non-responsive and you say, hey, I want to sign our son up for soccer, do you agree? And the other parent just doesn't respond, and then you miss the registration deadline. There's no other way to say it, but that sucks. Sucks for you, sucks for the kid. It's terrible. So you need something in there that says if the parent doesn't respond in X amount of time, it's assumed you can go ahead with the decision. Like little things like that you don't know to add that must be in your plan, or you're going to just be coming back and spending time and money on this later. So get a good plan the first time. That's really important. But you know what? You probably might be watching this and think, I don't have a lot of these things in my plan. I bet you're thinking that. And if you are, and you're thinking about modifying your parenting plan, it's really hard. So I'm going to put that out there too. I did a webinar on parenting plan modifications. I'm not going to tell you have to go watch it, but modifying a parenting plan, a major modification, especially to the residential time, requires a showing of a substantial change in circumstances that couldn't have been contemplated when you entered the first plan. If you have other minor modifications you want to make, I want to change my decision-making protocol. That's another thing that's in the plan we haven't talked about. If I want to change a provision or this or that, those are minor modifications. You might be able to do it, but you have to go through a modification, and you have to determine if you're asking a major or minor modification. That's a new action. You have to serve that on the other party. You guys can agree too. A lot of people will agree on making minor changes, but it's a modification to change your plan. So anyway, all right, Melissa, I know there's more. I'm sure there are. So I'll let you ask.
So many more. So
yeah,
many more.
if we don't get to all of them today, because I don't think that we're going to, and you know, I wish I had more time today, but I don't, then you are free to look at it for another webinar, join us another time, come to my meetup group that we host, I believe is next week. Is that right? I can't keep track of the weeks right now. Next week on Wednesday evening, we're doing Zoom version. We do in-person sometimes and Zoom sometimes. You're free to come there and ask questions. Or if you really have a case that you want to talk about, you can call us or go online and schedule a consultation with me or somebody else.
Okay. Lots more questions. Let's see what we can dive into here. Does the same apply for committed intimate relationship disillusions?
Committed intimate relationships with children, you're still going to need a parenting plan. The question is just going to be, what committed intimate relationship, actual partition part of the case refers to your assets, but if you have unmarried parents, you still can get a parenting plan. So all the same stuff applies. It's just going to be a question of how you plead it, which means how you bring the action. Are you bringing the action for the parenting plan at the same time? Did you already bring a parentage action before, which you could have if you're unmarried parents, and now you're bringing the committed intimate relationship later? All kinds of things like that can happen. But if you're unmarried parents, let's just strip it down to that. Unmarried parents, yes, you can and should get a parenting plan. And yes, you can and should have to pay or receive child support.
Okay. And so another clarification point. So there's not a visiting parent, right? Both parents are considered custodial parents. There's not.
Yeah. The parenting plans, the way that a lot of them are written too, will read like parents reside with parent A, except for when they are with parent B. So, I mean, people will talk about visitation. That's not really, like, in some situations, sure, it's a thing, like a parent is visiting if they have day visits or something. But like most of the time, you have your residential time, and the other parent has their residential time. You guys both have physical custody at some time, and you always, usually, assuming you have joint decision making, both have legal custody. So that's why I started out with those very basic terms in the beginning. Yeah. Although it can be difficult to understand. And I'm going to tell you this too. This is like real talk for a minute. I can talk about this like this because this is what I do. And I speak this language. Everybody doesn't. And it can be super overwhelming. So, and I talk really fast. So if you are doing this and you were coming up with a parenting plan, and I don't care how you're doing it, if you're doing it on your own with the other party, which I don't recommend, but if you are doing that, or you're working with an attorney, or you're working with whoever, a parenting coach, or whatever you're doing, slow down. Make sure you understand what you are agreeing to. I cannot tell you the number of people that we have later that want to change their parenting plan or didn't understand what it meant or this or that. This is very important. It is I tell everybody that works with me and for me and everybody else, is more difficult to change your parenting plan later than the first time when you're getting it. So make sure you understand what you're doing. Make sure you understand the implications of it. Don't just think you should download a plan and fill it out, because you could be stuck with that plan for many, many years. So just slow down and don't expect that you know and understand all of this or that you should speak this language, because it really takes years to seeing hundreds and thousands of different parenting plan situations to know all the kinds of things that could happen. You only need to know what pertains to your situation, but you don't know what you don't know. So at least talk to somebody and get some information. So anyway, go ahead.
How can visitation work if the non-custodial parent lives in another state? In this case, the child is 13.
Okay, I'll give you a little highlight on, since we're talking about custody, I'll talk about long distance parenting plans for just a minute. Long distance parenting plans where someone lives in another state are a different type of parenting plan, right? Like you are not going to see your child all the time if you live in another state. There's a big difference between Seattle to San Francisco, though, or Seattle to Portland, or Seattle to Spokane, and Seattle to Miami, or Seattle to Paris is another one I've seen. So what the plan is going to look like is going to depend on that. But what it's going to look like is one parent's going to be the primary residential parent. And that's going to be where the child lives during the school year, right? So child's going to live there during the school year. That's just how it's going to be. But like, let's say you're a West Coast type of situation. So then the other parent is going to have most of the vacations and most of the summer. That's just how it's going to be. But if the other parent is like Portland or West Coast or somewhere where it's not a crazy time change or flight, and they have the means, this is the other thing. If they have the means to do it, that parent might want, hey, every month I have a 3-day weekend where I come there. Or if the child is older, every month, the child comes here, although that's pretty difficult with school. So usually what it looks like if you had a 13-year-old and that parent wasn't going there once a month to visit, or I have one client actually right now even who goes to Austin, Texas to visit his child, and the child is young and the child lives there, and he goes there once a month for like 4 days. Sometimes he goes twice a month. Yes, we have it in the plan, so he has the option to go twice a month if he can with the proper notice, but he always goes once a month. Not everybody has that ability to do that, right? When the child is younger and the kid can't go on a plane alone, so it makes sense for him to go there. When children are older and they can fly unaccompanied, that's a whole other thing that you need to factor into your plan. When you're going to agree for the child to fly unaccompanied, that's usually a joint decision. But if you have a 13-year-old and let's say it's like West Coast parenting plan, then they might have a monthly visit, but realistically it's going to be all 3-day weekends. Like we're coming up on Veterans Day, it's like tomorrow. So that would be like a 3-day weekend. It's usually Veterans Day, Memorial Day, Labor Day. And it feels unfair sometimes to the primary parent because they're like, geez, this parent gets all the vacation time. Well, yeah, they do, because they don't get to see and be part of the child's life the rest of the time. So they get most of the 3-day weekends. They usually get majority of the summer. They'll usually get like at least a month in the summer, more time during the summer, depending on how close you are and what that looks like. They usually get, most of like spring and midwinter break. Those are breaks that would usually go and be spent with the other parent. And then usually still it's normal to split the holiday break. So yeah, long distance parenting plans. I also mentioned that too for people that are local, where if you have, just the other part of the state even can look like that too, even though it's more common to have a weekend. So I hope that helps. I'll take one more and then I'll go over a few more things.
Okay.
Is there a lot of them? I'll just take a few more. Keep going. I'll try to be quick.
Okay. How do you get primary custody of a young child under 2 if it's better for the child, but the other parent doesn't agree? Can you get recommendation from a child therapist or expert? Currently, they're doing 50-50.
Yeah,
and
50-50.
There's another question that we can kind of tie them together. There's some of the biggest factors in just determining physical custody, right?
Mm-hmm. Mm-hmm. Let's talk about, but before I talk about that, let's talk about, you asked a good question, and it was about evaluation, right? Okay. And how do you deal with it if like the parents don't agree? And here's a really good question. So Most of the time, people don't agree. It's actually pretty rare that people are like, this is the plan that we should have, and this is what we're going to do, right? And so in a situation like that, what do you do? Like, how do you really figure out who's going to have the time? Well, what the court's going to decide. But what a court wants to do is a court wants a recommendation. They want to not have to just hear about your kids and your family for a few minutes. They want somebody to do an evaluation. And when they do that, you're going to have different types of evaluators. You're actually required, like in King County, to work with family court services if you're on your own and you can't settle a parenting plan, and you can't do it. Then they're gonna meet with you and make a recommendation because the court wants a recommendation. So that can become from family court services. Although I highly recommend, if you have the ability, to use a guardian ad litem or a parenting evaluator. A guardian ad litem is a person that will stand in the shoes of the child. They'll talk to both parties. They'll talk to other collateral contacts involved. They'll observe you with the child. They'll make a recommendation. And the court won't necessarily follow it, but it's highly helpful for the court to have, and sometimes they will. A lot of courts will. So yes, you can get a recommendation to do that. Here's what I'm going to tell you. I'm going to go over like the basis for establishing a parenting plan, because an expert's going to look at that. Everyone's going to look at that. I talked about the best interest standards, and I talked about restrictions. The court's going to consider whether there is a basis for any restrictions first before it gets to anything else. And then it's going to consider other things that are part of the statute. And that is the relative strength, nature, and stability of the children's relationship with each parent. This is the most important factor: the strength, nature, and stability of the relationship with each parent. It just is. And they're going to look at that. And this is usually given the greatest weight by the court. But here's the thing. The court also is going to recognize if you were just divorcing and one parent wasn't home that much because that was just their role, they're not going to hold that against the parent. But that stability and strength and the nature of the relationship, the agreements the parties might have entered into before knowingly and voluntarily. So if you were in an agreement where you guys have agreed, you haven't had a parenting plan, but you've been separated for 2 years and you've been doing the same thing, court, that's going to be persuasive to the court. Each parent, this is the other one, I'm trying to remember the exact words, but I think it's each parent's past and potential for future performance with parenting functions, and whether one parent has historically taken greater responsibility. So they're also going to look at that. Like if you were always the parent that went to the doctor's appointments, doesn't mean you always get to be, but why? Like, was it because the other parent was working, or was it because that was just your role? But they're going to look at like what your ability is to perform future parenting functions. And that's really important, because you could be like, well, he never had the kids overnight, hardly ever. Well, but is he capable of it? If he's capable of it, he's going to get a chance to. They're going to look at that. They're going to also look at the other kids in the home. Like, what is the stability here? We can't have a schedule that has a totally different schedule for a 2-year-old and a 10-year-old. Are there multiple kids in the home? So those are things to look at as well. They're also going to look at what the child wants. If they're older and there's a custody evaluation, children never get to make a choice about where they live. So it's a common misconception that my kid's 12 or 13, they can decide. No, not the case. People ask me all the time, how old does my child have to be when they decide where they live? They have to be 18. So they don't get to make the choice. But if you have a custody evaluator and they talk to your child and the child's a teenager and there is a sound reasoning behind that, it's going to carry some weight, and then they're going to look at why. It's different than a 5-year-old's like, I always want to be at mom's house because I get to have candy and watch TV there, or whatever. Like younger kids, their perception can be different, and younger kids, they just don't necessarily they don't have the same facility for logic and reasoning because of developmental reasons. So older kids are going to be listened to, but that they don't get to make the choice. Like, and it's never a good idea for anyone to say to a child, where do you want to live? Like, that's really like just a really bad idea. So it all is about like what is in the best interest, but it's really like who can take care of the children's physical care and emotional needs, who can provide for, I mean, the objectives really are like, who can provide for the child's needs, who can, shield the child from bad things happening as far as like conflict with the other parent. If one parent is creating a lot of conflict, that can be a basis for a restriction. But at the end of the day, it's really about what's in the best interest. And it's the most important thing for you to know is both parents are going to share time with the child, whether you like it or not, unless there is a basis not to. And a basis can be distance. A basis can be one of the restrictions we talked about, any number of factors. So I hope that helps. Okay, Melissa, I'll take another one.
Okay, this one's a little bit too fact specific. I'm going to try to pare out just the main ideas. They're talking about how they have primary custody right now, and has the daughter during the weekdays, getting ready to go to mediation. The other parent is asking for 50-50. They're considering it, but I guess there's some issues around kind of the daycare pieces, and maybe he doesn't get off work in time, so daycare payments and things like that. We're looking at like, how does, potentially moving to a 50-50, but also having to pay for a child care sort of situations, how any of that affect child support payments?
Okay, well, I'll give you, this isn't a child support webinar. I did one on child support. Go watch it. It's on the YouTube page. But I will tell you this. Okay, the parent that has more nights, there's a child support calculation. Child support is based on the income of the parties and the Washington State child support schedule. It tops out at combined income of $12,000 a month. And based on your income determines what the child support is and how many kids. So the parent that has more nights is presumed to get child support from the parent who doesn't have more nights. The number is figured out by that calculation. Each party has a share of what that total child support number is. That's based on income. So if one party makes $50,000 a year and one party makes $100,000 a year, there's going to be a pro rata proportional share based on the income. And then the parent who pays one proportional share, they pay their percentage of the child support payment to the other parent. That's how it works. And the proportional share is important because if you have work-related daycare, like if one parent is like, oh, I have to work until, this is very common. If you're a parent, I got to work till 5 or 6 and I can't pick up my children and they need aftercare. Aftercare is super important, whether it's YMCA or whether it's a private provider or whatever. I need aftercare. Both parents will share in that expense for either parent and they'll pay their proportional share, unless there's an agreement that you each pay for your own childcare. But the statute in Washington requires that both parents pay for work-related childcare. So you would pay your proportional share for that time. A parent needing childcare, like for work or something, is not a reason for them not to get residential time. A lot of parents have a hard time wrapping their mind around this because they're like, well, I'd rather have the child be with me. I'm available. That comes down to another provision about custody, which is the right of first refusal. You can have it in your parenting plan that if there's one parent's not available for a certain number of hours, they have to offer it to the other parent before getting childcare. But courts really frown on right of first refusal, especially for limited time. Maybe for an overnight that makes sense, but for the most part, they don't want to control the other parent's ability to care for the child. Or with a really young child, you could have a right of first refusal for a period of time if that's easier and the parents live really close together. If they don't, it's not going to happen. But anyway, you'll each pay a proportional share for childcare. Childcare is not a reason not for someone to have residential time, unless they have a really crazy schedule, like for days at a time or something. Does that make sense? I think so, Melissa. Okay, the next one.
You mentioned an organization earlier that somebody wanted to have you repeat. It was at AFCC.
Yeah, Association of Family and Conciliation Courts. The Association of Family and Conciliation Courts is heavily, it is basically what the parenting evaluators and guardian ad litems, they do their trainings. I've gone to many of their conferences. They give great conferences for family law professionals, but they have some guidelines that I think are probably publicly available. They used to be, and it kind of talks about developmentally, and it's really helpful to kind of go through it and go, hey, okay. There's also information on their webpage about parenting plan evaluations, and so you might get a better idea then about what would happen in an evaluation. But really, you should talk to an attorney about that, because the evaluator that you use, the type of evaluator that you use, is going to be really important as well, and what they're going to do.
Okay. Another person's asking, they said that they have a guardian ad litem involved who suggests that their custody should be 50-50 and supervision should be lifted as soon as possible. However, the other party has stopped responding to us. So would this be bad looking for them when we go to trial? I don't know.
I don't know what that means.
Yeah.
I guess like if here's the thing, if your guardian ad litem is recommending 50-50 and no supervision, then there's probably a reason why. Here's another thing to throw out there for you, for anyone that has a parenting evaluation and might be going to trial. If you have that kind of a situation and you have a report that you don't agree with, it doesn't mean that it's the be all end all. And many times me and other attorneys will hire another expert to look at the report. I have a case right now where the report's terrible, and so we're trying to get the report thrown out, and I think we will, or at least I say not considered. So the parenting plan evaluation or guardian ad litem report or parenting evaluator report, especially a report from CASA, Court Appointed Special Advocates, or FCS, it might have something wrong with it. It might not have considered everything. But a lot of the time, the reports are very good. I can read a report and be like, wow, they did a good job. Even if I don't like what they said, I can say, okay, I don't see a lot of holes here. I can look at another one and be like, they didn't consider this, they didn't consider that, they didn't talk to this person, blah, blah, blah. So it really depends. But if you have a plan, an evaluation that's recommending 50-50 and no supervision, then you are going to need to tell the court why that shouldn't happen, or the other person is, depending on whose case it is. If the other person's not participating in the evaluation, then the evaluator is going to note that, and the court's probably going to wonder why. So, yeah.
Okay. Okay, could you speak a little bit more about the reasons for relocation? If somebody wants to potentially block or do a rebuttal on a relocation, can you help and how you might block one? So I'm going to also piggyback onto that. Somebody else asks, what's the best location to go to view your past webinars?
I'm not actually the one that puts them all up on the webpage, but if you go to our website, let me actually just go to it right now. I think it'll link to it. If you go to our website, which is DELLINOLAW.com, dellinolaw.com, and you go to news and resources, which is right here on the top, and then you click on webinars, it'll tell you how to register for this one. And it says, click here to view our library of webinars on our YouTube channel. I think a lot of them are up there. Oh yeah, there's a bunch of them up here. I don't know if this is all of them, but there's a good number of them up here. So then you can go to it. I'm actually looking at the page right now, and it'll just take you right to the page. So if you want to go and look at these, you definitely can. Recent ones include understanding divorce process in Washington State, domestic violence in Washington, family law, prenuptial, postnuptial cohabitations, property division, restraining orders, modifying parenting plans. Yeah, I thought I did a relocation one. I'm not totally sure.
I just thought I made it up there. Yeah,
it might not be up there yet. But anyway, you asked about relocation. So here's the thing. There is if you're thinking like you want to stop a relocation from happening, the parent that has the ability to move and the presumption that the relocation will be approved is the primary residential parent. Here's the thing for you to know though, if you have, the more time that you have with your child, I tell my clients this too, if they're really worried about the other parent moving. So I'll tell you this, if you're worried about the other parent moving, even if you're not going to be the primary parent, make sure you have residential time with your child every week and make sure it's more than once a week. If you're every other weekend parent, unless there's a really good reason, the other parent's going to get the move, probably. But if you are a parent where you're every other weekend, but in the off weeks, you also have a couple overnights, it's going to be harder for that parent to get the move because it's disrupting the contact with you. And to stop the move, you're basically going to have to be saying the court will have to agree that it's better for the child to stay here with you and be primary parent than go with them. The court cannot stop the other parent from moving. They can't restrict the other person's ability to live where they're going to live, but they can say the child stays here then, and then you get the long distance plan if you decide to move. So that's kind of what the court would have to think in order for that to happen. But I would recommend that you either watch a webinar on that, do a consultation on that, or get some resources on relocation.
Okay, modifying a temporary parenting plan, is that as hard as you mentioned before with modifications of plans?
Yeah, I mean, let's talk about the difference. That's one thing I wanted to touch on before I wrap up. Temporary plans and final plans. If you have filed for divorce or unmarried parents or whatever it is, and you need to get basically a new status quo, here's the thing for you to know. A divorce or separation case is a marathon. It's not a sprint. It's going to take a while for it to be over. So what you're going to want to do is get a temporary plan in place so you have like a new normal and a status quo to follow while the case is pending. You can do that by seeking a hearing on temporary orders where the court will put into place a temporary plan, or you can do it by agreeing with the other party. You can mediate on it, a number of things. But once you get a temporary parenting plan and that's in place, then that is going to be your status quo until there's a reason to change it before trial. And most of the time, you're not going to be modifying a temporary parenting plan unless there's like a reason to, unless something happened that couldn't have been foreseen, like I don't know, or a parent got arrested for doing something that was really dangerous to the child, or I don't know, something happened that was really bad. I've had recommendations even from guardian ad litems or parenting evaluators before trial, and the court is often hesitant to change the parenting plan again until trial. So modifying a temporary plan is probably not going to happen unless there's a reason to, or unless one parent like moves further away, or it's affecting, or something's happening where the child's not getting to school on time. There has to be a reason though. So just doing it because you don't like the schedule is not going to happen. And I have room and time for a couple more, and I'll take those and then I'll wrap up.
Sure. So somebody's asking about the meetup group, so I'll just answer that to give you a second to breathe. Also on the Dellino Law Group website, under news and resources, you can find a link to register for the meetup group, which is next week on Wednesday, the 15th at 5:30 p.m. Via Zoom format. And you'll hear from Michelle at that group. Myself, we'll talk about emotional issues, legal issues. There's also a real estate advisor person to talk about real estate issues, financial issues. We have 5 professionals on the call. So we would love to see you there. 5:30 on Wednesdays, and it's usually once a month. Next question is, does the court like it if you make a parenting plan with a family coach, or do they not really care?
Asking me about coaches is the wrong. Okay, the court doesn't care. They don't care if you agreed on a plan and like a parenting coach, or not say parenting coach, but like somebody sat down with you and tried to help you with it. There are some specific professionals that do that. Some of them are great. Others of them are not. And it doesn't matter. It's not a substitute for legal advice. I have people come and they're like, oh, we sat down with this coach and came up with this plan. And I'm like, this plan doesn't make any sense for you. But anyway, a court doesn't care. If it's helpful to you and you want to do that, great. It should not be a substitute for getting legal advice about what your rights are or what a court would be likely to do. But a court doesn't care if you do that. If you're at trial and you're having one of these people testify, it's going to be a question. It's going to be a question about like what they're testifying about. Like if you guys had an agreement, they probably wouldn't even be there. But a coach is not going to ever take the place of a guardian ad litem or parenting evaluator, and they're not qualified to weigh in on establishing a parenting plan and making a recommendation to a court. If it's helpful for you, that's great. I'll leave my comments about coaches to that.
Mm-hmm. How should you deal with minor violations of a parenting plan, like drop-off protocol or not reimbursing for expenses in a timely manner? When should you kind of raise it to the attention of taking it to court?
If a parent doesn't comply with the parenting plan, you can seek to hold them in contempt of the parenting plan. Do not be the person that's like, I'm seeking contempt because someone dropped someone off 10 minutes late. Like the court's going to be like, stop wasting my time, and that's not going to be good. But if someone violates what I talked about earlier, decision-making, that is decision-making is appropriate. I would seek to hold someone accountable right away, unless it was just like an oversight. If it is a habitual thing, you might want to put them on notice and say, this continues to happen. And when it continues to happen, it needs to be stopped. Otherwise, we're going to say this parent was late for drop off 15 times or whatever. Minor one-offs, I would try to resolve with the other party or through counsel. Sometimes just getting a notification from the other party's attorney that this happened, it can't happen again is enough. But if it continues to happen, you don't want to be someone that doesn't seek contempt and doesn't do anything and deviates from the schedule. This is very common. Parties can make other agreements about the schedule anytime they want. You could have an every other weekend plan, but really you've been doing 50-50 for 2 years. Then all of a sudden you decide you don't want to do that anymore. Well, you probably have an issue because you are integrated. Then you're integrated into the other parent's home. But anyway, if it's a minor violation, try to resolve it. If it becomes a habitual problem, then I would seek enforcement of that provision of the parenting plan in court.
We do have some more questions, but I wanted to know, Michelle, if you want to take a couple of minutes just to talk about a few holiday tips. Yeah,
I didn't get a chance to really do that. Sure.
We can't go into depth, but maybe we could just.
Yeah, and I think like here's the big thing. I'll tell you, this is like a little anecdote, and that may or may not be helpful. My first job was as a public defender, but my second job was I clerked for a superior court, and so that meant that I was like the staff attorney for several of the judges. And I'll never forget sitting there one morning. It was right before the holidays, and one of my judges was like, I hate the domestic calendar. Never be a family law attorney, because this is a time of year where, it's all joy and happiness and people fight tooth and nail over their kids, and it's horrible. And he said some other choice comments, and I was like, wow, I'm never going to do family law. And here we are. But anyway, the point of that really is that tensions and stress are high around the holidays. And the best defense you can have to dealing with problems with your holiday parenting plan is to have a solid parenting plan. I didn't get a chance to talk about this, but residential schedule is one thing. Holiday schedule is another thing. Your parenting plan will have designations for who's going to have what holidays and what that's going to look like. And you want to make sure that you have an equitable and fair holiday schedule with really clearly defined drop-off times and pickup times. A very common thing that happens is, okay, school break is like 2 weeks, right? And so how do you split that? It's hard when the big Christmas days are the 24th and 25th, and maybe the midway point of the break is not there. So some people will say parent A gets gets this first half through this time. Parent B gets this first half through this time. And then the next year it flips. They both get different times. Some parents will say it stays the same schedule, but then there's a specific schedule just for those days. Other people might be celebrating things like Hanukkah earlier in the month or later in the month, depending on when it falls. Or Diwali is another very common one that is in the month before. And there's other holidays that happen, but having a clearly defined schedule is really important. If you don't, my tip for you on dealing with it is to deal with it now. Start dealing with it now. Be like, it's not clear when this is. Communicate with the other parent, always in writing, preferably in email or text, or if you have the agreement to use Our Family Wizard or Talking Parents or one of these applications, in there, set forth what you want, what you're proposing. Give the other person a period of time to respond. This is all assuming you don't have this in your plan or your plan is vague, because I see some plans and they're terrible. They're not clear. And then someone might be like, a really common, a sad one is like, I want to take our child to the Nutcracker. We got tickets on this day. It's not on my residential time. What are we going to do? Act like a decent human being. This isn't a legal tip. This is a tip where it's like, I want something from the other parent, and don't just be like, I want to take them. This is the only time we could get tickets. Reach out and say, I really want to take them. I think they would love it. It'd be really fun for them. I think they'd be excited about it. I'd love to offer you another opportunity too on my time if there's something that you want to do. Offer, be reciprocal. So when you're looking to make deviations around the holidays, people are sometimes another thing is grandma's coming into town. You didn't know she was coming. She's only coming on these days. It's on the other parent's time. Obviously, you might not swap the entirety of the time, but you might say as early as you can, I'd really love it if our kids could come over on these 2 days, or if we could take them here on these 2 days while my family's in town. Would you like this instead? You know, and if they say no, okay. Then they say no, then you can maybe try to get someone else to approach them, or you can just accept that's not going to happen. But the sooner you give notice before other people make plans for proposed deviations, the better. And offer something in return is my biggest tip. And be nice, be nice, be nice, be kind. That's one thing to say. Here's another tip. And this is maybe unpopular with some people, because divorce can be really nasty. You can end up not feeling good about your child's mom or dad. That's just the reality, but they are your child's mom or dad. And I think a really good tip is for you're not going to like this, to give the other parent something for the holidays that they can share with the kids. You know, for example, like I might not be best friends with my husband's ex-wife, but I'm going to make sure that she gets something for, you know, whatever, something like a holiday basket with something that she can share with the kids, right? I'm going to make sure that happens. Someone else is going to make sure that it happens, that you recognize that parent's birthday, you recognize them at Christmas, you recognize them as the other parent of your children, and you make the effort, even if you don't have a great relationship with them, to show goodwill, because that's the kind of example that you want to share with your children. It is important never to talk negatively about the other parent, no matter how you might feel about them, especially at the holidays when people are like, oh, your dad won't let me take you to this. Don't ever do that. Just don't. You can vent about it to your friends and it might be true, but the children don't know how to deal with that, and it makes them feel very conflicted. So show some grace, have reciprocity, take the high road, try to set up plans as early in advance as you can. And if something comes up last minute, just be really honest about it and be like, I'd love to do this, but I understand if we can't, but I want to offer you something. I hope that helps. It can be a very, very stressful time. You don't want to be one of those people on the, calendar right before Christmas fighting tooth and nail for your kids. That you just don't. I became a family law attorney to try stop that from happening. And then I realized later, I can't stop it from happening unless I write a really good parenting plan. Even then I can't stop it from happening when life comes up. So just trying to help people navigate through it the best they can is kind of the best we can do, but you are really in control of that, not me. So I wish you the best with it. Thank you for coming. I hope this was helpful. Like I said, I told you in the beginning, I could literally talk about custody probably all day. I enjoy talking about it, but we don't have that much time today. So come to another webinar, come to our meetup group. If you really have a family law issue you want to consult on, schedule a consultation. If you are in the need of counseling, or even if you're just not sure if you want to go through with this process, talking to Melissa can be really good, or someone like her. Melissa she has a specialty in people going through relationship transitions. So she can help you, basically with ambivalence therapy as well, if you're not sure what to do, or she often works with people who are going through a difficult time emotionally. And I'll tell you this, like I have a lot of clients where they would not make it through the process at all, like in a good spot without a therapist, because they can talk to me about all their issues, but I can't help them process it. And it's really expensive. It also keeps your fees down in a family law case if you have a therapist on board. So that's just really, I think, practical advice when you think about custody. It's so emotional. It's so difficult for everyone involved. So take care of yourself during the process as well, and that'll help you take better care of your kids. Thanks so much. I hope you have a good day.
Yes, thanks everyone. I'm sorry we didn't get to all the questions, but we sure did get to quite a few. So come back and see us again, and definitely reach out if you are in need of resources. Okay, take good care, everyone.